Welcome. I'm Marisa Barlas, Associate Director, Advancement Gift Planning at York University. Thank you for joining us today for our special Life Skills series, Wills and Wealth webinars on the topic Wills and Estate Planning Tips and Traps. As this event is virtual and we're not all gathered in the same place, I recognize that the following land acknowledgement might not be for the territory that you're currently on. As a member of the York University community, I recognize that many Indigenous nations have long-standing relationships with the territories upon which York University campuses are located, which precede the establishment of York University. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Takaranto has been caretaken by the Nishnabeg Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It is now home to many First Nation, Inuit, and Métis community. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject of the Dish with One Spoon, Wampum Belt Covenant, an agreement to peaceably care for and share with the Great Lakes region. As we begin, we'd like to actually get to know our audience a little bit better, so we'll launch a quick poll. Today's question is, where are you currently with your will and estate planning? A poll should pop up on your screen, and I'll give you a few moments to respond. Great. Thank you, everyone, for participating. It's always helpful for us to know and for our speakers to know and gain a better sense of who's in our audience and where you're at with the topic of discussion for today. So thank you for sharing. If you should need help with our Zoom webinar today, feel free to click on the Q&A button at the bottom of your screen and enter your question, and our staff will be working behind the scenes to help you. Also, that same Q&A button can be used to submit your questions for our speaker to answer during the question and answer session, which will take place at the end of the presentation today. Please keep your comments relevant, and the team will watch for them and send them our way. And now I'd like to warmly welcome the guest speaker of our webinar today, Rebecca Studin. Rebecca Studin is a partner at DeVries Litigation, LLP. Prior to joining the firm, she practiced estates and commercial litigation at a full-service international firm in Toronto. Rebecca is an estates litigator who acts for clients in respect of a broad range of estate matters, including will challenges, will interpretation and rectification applications, contested guardianship, powers of attorney disputes, complex probate applications, and contested passing of accounts. She obtained her law degree from Osgoode Hall Law School in 2008 after earning her honors Bachelor of Arts degree from our bilingual Glendon College campus at York University in 2004, and thus she is fluent in French. Following her call to the bar in 2009, Rebecca was selected as a Fox Scholar and spent a year training as a barrister in the Middle Temple Inns of Court in London, UK. We are pleased that she's able to join us here today as our speaker. Welcome, Rebecca Studin.
Thank you, Marisa, for that warm introduction. I'm just going to get my presentation on the screen. So good afternoon, and thank you for having me to give this presentation. I'm very pleased to be here. And as you will have known because you registered for this webinar, the topic of my presentation is called Wills and Estates Planning Tips or Traps. But as you will have heard from my introduction, that I myself do not practice in wills and estates planning, although what I am is an estates litigator. So I don't draft wills, I don't draft powers of attorney, I do not give estate planning advice. So why am I giving a presentation on wills and estates planning tips or traps? It's because I see what happens in my practice when estate plans go awry. And so the purpose of my presentation is to introduce various topics which I see in my practice as being frequently the subject of litigation, so that you, as listeners, wherever you are in your estate planning, and I see that based on the poll that was given to you at the start, that your estate planning are various levels or various degrees of preparation, that you can take it on board, apply it to your situation, and speak with your estate planning lawyer or your drafting solicitor, and try and avoid and minimize the risk of litigation down the road following your death, and to make sure that your wishes are carried out. So having said that, I'm going to move on to my topics. There are 6 of them. The first is holographic wills or handwritten wills. Second topic, frequently the subject of litigation, is oral promises. Third, uncooperative co-executors. 4, sudden disinheritances. 5, joint accounts and resulting trusts, and I'll explain that concept later on in my presentation. And then the 6th is closely related to joint accounts, are beneficiary designations and resulting trusts. So moving on to the first topic, holographic wills. And for those who are not lawyers, a holographic will is a handwritten will. Handwritten wills can absolutely be valid wills. The only requirement is that it be written entirely in your handwriting and that you sign it. These are considered valid documents. However, it doesn't mean that simply writing something down on a piece of paper makes it a valid will. And it is often can be the subject of litigation, or at least a court application by your executor asking, is this piece of paper that the testator or that the deceased wrote a will or not? I can't tell. I found this document amongst the deceased papers. I simply don't know if this is a valid will or not. And to give you an example of a case where this topic was the subject of litigation or a holographic will, it's Gibbon Estate and Sleeping Children Around the World. It's a 2010 Ontario decision. In that case, the testatrix made a will, a handwritten note rather, in 2007, 3 years before she died. The note was found by her estate trustee among her papers. The note began with the heading, "To be added to will," and then it gave a list of bequests, bequests meaning gifts that are given in a will. The estate trustee was unsure what to make of the note and asked the court for an interpretation. And the court found that the note lacked testamentary effect. It was a statement of information for a future will only, and it was not a valid will. And what the court said about the law on this issue is that a duly executed instrument described as instructions for a will may have effect as a will if it appears that it was intended to take effect in the absence of a more formal instrument, a more formal instrument being a formal will that's drafted by a lawyer and signed with all the formalities. And in this case, the testatrix did not intend for the handwritten note to have testamentary effect. In fact, when the testatrix wanted to make changes to her testamentary dispositions, she had done so by either making handwritten notations on her actual will, which were later incorporated into a subsequent will, or by visiting a solicitor. So the handwritten note was therefore inconsistent with the testator's past practice. So what you can take on board from a case like this is beware of making handwritten notes that you leave around the house that could be interpreted by someone after your death as being a will. And that doesn't mean don't take notes or don't make notes of how you want to dispose of your estate after your death for future discussions with your lawyer, but you should make it clear on that paper that you're not actually intending it to be a will unless you actually do intend to make it a will. Otherwise, it could give rise to litigation or uncertainty. And then it looks in this case that I just described, Gibbon Estate, the court ordered that it was the estate that was to pay the costs of the application to the court, the executor's legal fees and et cetera, and preparing the application came out of the estate. So that means it's less money to your beneficiaries, and nobody wants their estate to be depleted by legal fees if they can avoid it. So be careful with the handwritten notes. Another example of where the opposite conclusion was reached is the case of Ludlow and Clubb. Here, before he died, the testator had transferred a cottage into the names of 2 of his children. He later asked his 2 children to add his 3rd child to the cottage title, but they refused to do it. In response, the testator made a signed and a handwritten note indicating that he wished for that third child to receive a cash sum in lieu of receiving a third interest in the cottage after the testator's death. And the court declared that note to be a valid and subsisting holographic codicil, a codicil being a document that amends a will to the last will and testament of that testator. And the law, as the court said in that case, is that a holographic paper is not testamentary unless it contains a deliberate or fixed and final expression of intention as to the disposal of property on death. Further, the onus is on the moving party to show by the contents of the paper and by extrinsic evidence that paper is of that character and nature. And here the court had found that this handwritten note of the deceased had testamentary effect, so it was valid will. The note was clear that it should modify the testator's prior will. The testator signed the note with his full name, followed by a signature, dated it, and placed it in an envelope. And the testator had gone to a lawyer to ask about how he could fix his mistakes of not transferring his cottage to all three of his children equally. So at the end of the day, it's really unclear what the result will be, and you just don't know. So there is risk to having handwritten notes and making holographic wills if there's any ambiguity about what your estate's plans are, what your intentions are, or if there's any disagreement about your beneficiaries as to which note is valid, and they might have competing interests. So always best to go see a lawyer to make a will. Moving on to the second topic, or the second area that is frequently the subject of litigation in the estate's context, is oral promises. And generally speaking, oral promises, so I promise to leave you my house, or you'll get my cottage in my will, or I'm going to leave you this bank account. Promises of that nature are not legally binding, although they can be very disappointing to a beneficiary who has promised something and then that promise is not followed through in a will. Even if that promise has been repeated over the years, those promises in and of themselves are not legally enforceable unless, in reliance upon a promise, a would-be beneficiary takes steps and in reliance upon that promise that enriches your estate and causes a detriment to that beneficiary. A promise in that case has the potential of being legally enforceable. And an example of such a situation is Love and Schumacher Estate, a 2014 Ontario decision. In this case, the deceased had promised his friend, the deceased had inherited an old derelict cottage by the lakeside that he really didn't have any interest in maintaining or using. And his friend, the plaintiff, expressed interest in visiting this cottage and did so over the years and developed an attachment to the cottage with her daughters. And it became an annual trip. And he promised that he would leave this cottage to her in his will. And on the basis of that promise, the plaintiff assumed responsibility for the maintenance and upkeep of the cottage and spent over $100,000 of her own money in making upgrades to the cottage, effectively making it her own. Before his death, the deceased changed his mind and left the cottage to his son and didn't leave it to the plaintiff, and she sued his estate. And the result of that litigation was that the court granted the plaintiff a 15-year license to exclusively occupy the cottage. And the plaintiff was able to succeed in her claim on the basis of two legal concepts: proprietary estoppel and unjust enrichment. So what is proprietary estoppel? It is where, so it involves encouragement or acquiescence. So here, in making the promise to the plaintiff to leave the plaintiff the cottage, Lee, who is the deceased, encouraged the plaintiff to spend her meager funds, her time and her labor in improving the cottage. Although he may have unknowingly encouraged her, his promise certainly induced her into a state of affairs where he acquiesced to what she was doing. So he let her go off and make all sorts of improvements to the cottage, and there was evidence that he even promised to gift it to her. And in fact, he had left it to her in 2 draft wills that he never signed, and then he changed his mind. In addition, she had satisfied the requirement of detrimental reliance. So she, in reliance upon the promise, suffered a detriment because she spent her time and money improving the cottage. And the third requirement was that it was unconscionable for the deceased to have made those promises that she relied upon and that he did not leave her the cottage. And there was no reason why he didn't leave it to her other than he just changed his mind. So And the other element that she satisfied that entitled her to this license was the concept of unjust enrichment, which we often see in estates matters. So enrichment, through her labor and financial expenditure on the cottage, the plaintiff increased its value. And there was a corresponding deprivation that she suffered by making those expenditures. So she enriched the estate, she suffered a loss, and there was no reason or absence of juristic reason for the estate's enrichment. The deceased had simply just changed his mind. So the court in this case was obviously not impressed with the testator's behavior toward the plaintiff and fashioned a remedy that would have given her something that she had been promised, as opposed to, say, reimbursing her for the money that she had spent. They gave her exclusive access to the property, which is what she really wanted. So beware the oral promises, unless you intend, beware of making oral promises that are inconsistent with your estate plans, because there will be risk of litigation to your estate if you change your mind and someone has relied upon your promise. There may be litigation even if you don't follow it, even if you make promises and there has been no reliance. But in that case, the beneficiary has a harder time proving their case. The next area of litigation that frequently arises in the state's context is uncooperative co-executors. So for those of you who have made a will or are thinking about making a will, you have chosen or have thought about who is going to be your estate trustee, who is going to be the person tasked with the duties and responsibilities of carrying out your wishes and executing your will after you've died. It's not an appointment that should be made lightly, and the person that you select should be trustworthy and someone that you can rely upon to do the job. That person doesn't need any specific skills or education in order to do the job, but you have to have confidence in them and know that they are accountable at the end of the day to your beneficiaries for what they do with your assets after you've died. Oftentimes, testators will plan to name two executors, such as children, their siblings, to carry out their wishes. They might do so because they don't want to offend one sibling or they trust both of them. But when you do that, when you appoint multiple executors, if you choose to do so, you should consider whether or not these people are actually going to get along in carrying out your wishes. If you have children and they don't get along and they hate each other, don't appoint them as joint executors. That is my word of advice. So an example of where litigation arose as a result of uncooperative co-executors is Mailing in Conrad, a 2013 Ontario decision. Here, the testator appointed his brother, his sister, and his lawyer as joint executors. His will was complex. It consisted of 2 commercial properties, a very large plaza, residential condominium units, cash, insurance, etc. The brother refused to cooperate with the sister and the lawyer in carrying out estate duties. The brother refused to give instructions, sign documents, provide keys to some of the properties. The brother also accused the sister and the lawyer of lying on various occasions. The result was that the brother was removed as an executor. And the court has the authority to remove executors. And this is under Section 37 of the Trustee Act, which gives the court the jurisdiction to remove a trustee, executor, or administrator. Any application for the removal of a trustee requires that due consideration be given to the wishes of the testator, which includes his selection of executors or administrators. Although hostility between executors alone may not be sufficient to disturb the testator's wishes, where a trustee prevents the trust or estate from being properly executed, he or she should be removed as trustee or executor. And here, in this case, the brothers' hostility and suspicions were unfounded and caused delay and potential cost to the estate and their beneficiaries. The brothers' lack of cooperation made it improbable that the executors could administer the estate. So this is something that all people who make wills should consider. Who will be my executor, and is this person up for the job? If I'm selecting more than one executor, are they going to get along, or do I anticipate that there will be friction and possible litigation removing one or both of those executors? And do I really want my estate to be delayed and reduced in value as a result of that litigation? Something to take on board when you go see your lawyer about making a will or updating your will. Another area that is ripe for litigation is sudden disinheritances, or changes to wills that reduce the gifts to certain beneficiaries when a testator is at a very advanced stage in life. This gets litigated all the time through will challenges. And the two examples of this are one, Fawson estate, which is a decision from Nova Scotia in 2012. In this case, at the age of 78, the testatrix disinherited her two brothers in her will. She died 6 years later, and one of the brothers sought a declaration that the testatrix lacked testamentary capacity when she executed the will. And what does testamentary capacity means? It means that you have the necessary mental capacity to make a will. And here the court granted the brother's application and set aside the will. And so although the testatrix here functioned with minimal impairment in her day-to-day affairs, she developed irrational delusions concerning her brothers. And these delusions were so strong that they impacted her dispositions in the will, rendering those dispositions invalid. Now contrast that result with the decision in Royal Trust Corporation of Canada and Saunders, which is an Ontario decision from 2006. Here, at the age of 96, the testator changed his will. To the surprise of his two children, who were beneficiaries under his prior will, they had been disinherited completely, except for each receiving a $20,000 bequests. And the testator left the bulk of his estate to a charity. The children challenged the will on the basis that the testator lacked testamentary capacity, and in this case, the will was upheld. Though it was unkind, unfair, and mean-spirited, the testator knew what he was doing when he decided to cut his children out. Now, I mentioned in the previous slide that the testamentary capacity. What does it mean? It means that in order for you to be able to make a will, you have to be of a sound and disposing mind. And there are 5 elements that would meet that test. The first is that you need to understand the nature and effect of making a will. You need to recollect the nature and extent of your property. You need to understand the nature of what you're giving under the will. You need to remember the people that you might be expected expect to benefit under your will, such as children or spouses, and that you need to understand the nature of claims that may be made by persons that you are excluding under the will. So in the Royal Trust Corporation case that I just discussed, here the court went through this analysis and found that the testator knew all these things. And so he turned his mind to the fact that he was leaving less of a gift to his two children and went ahead with it anyway. And his lawyer, who took his instructions, went through all of these factors with him to make sure that he was capable and that the lawyer was satisfied that he could take instructions from that testator and that he was capable of making the will in that lawyer's professional judgment. And so, are you allowed to disinherit people? Absolutely. In Ontario, you have testamentary freedom, much like in other common law jurisdictions in the country. You are allowed to leave your estate to whomever you wish, subject to your obligations towards your spouse and dependents. If you have any, your adult children don't have a right to your estate. And so you can make a will that cuts them out if you want. And the quote that I think is really prescient on this issue is that it is well recognized that a will maker may be capricious and unfair in making dispositions, but that does not of itself amount to a lack of capacity. Even will makers who were mentally ill and suffered from confusion, that condition is not determinative as to whether the will maker had the requisite testamentary capacity. Cognitive impairment or confusion alone is not grounds for declaring a person incapable of making a will. So what is the takeaway from this my topic of sudden disinheritances? That if you're planning on making a will that involves a sudden change or that plans to cut out a beneficiary or reduce their entitlement, that when you make that will with a lawyer, that your lawyer should take all the factors that I enumerated above regarding testamentary capacity on board, because you want to make sure that your lawyer's file is properly documented in case there is a will challenge, because your disappointed beneficiaries, the ones who were cut out, they will be asking questions and they may potentially bring a claim against your estate. And if you want your will to be upheld, you want to make sure that the lawyer's file is properly papered and documented, and And so it will be persuasive in court. Another area, going on to the fifth topic, that is frequently litigated is the subject of is joint accounts. And we all know what joint accounts are. Many people have them. It's where there are two account holders, and when one of the account holders dies, then the money can pass to the survivor. But that's not always the case in estates matters. And why is that? It's because it depends on who the joint account holder is. So for example, if you're an adult and you have a joint account with a child, and the money is yours and that child didn't contribute to any of those funds, you just put that child's name on that account, either for convenience or maybe you do intend them to inherit that money at the end of the day, that's not enough. The law presumes that after you've passed away, that child who gratuitously was added onto that account holds that money in trust for your estate. It's a resulting trust concept, and it's the definition of it is set out in the Supreme Court of Canada's decision in Pecore, which I've indicated on the slide that you're looking at right now. And so the person who receives, the child that receives that money by survivorship, doesn't automatically get it. It can be challenged by the beneficiaries of your will if they are different. And it would be up to the person who claims an entitlement to that money to advance evidence to show that the money was a gift and intended to go to the survivor. And it's not enough that they were simply just added as a joint account. So this is something to take on board. And an example of a joint account and resulting trust claim is Studin Estate, a 2012 decision from Ontario. And here, the testator transferred 7 of his bank accounts into joint accounts with a right of survivorship into the names of himself and his 2 sons. And the sons claimed that the testator wanted them to distribute the funds in the joint account to the testator's 7 children after the testator's death. However, the testator's will named a charity as the residual beneficiary of the estate. And the charity asserted a claim over the trusts in the joint account by way of resulting trust. And the court found here, in this case, that the children had rebutted the presumption of resulting trust. And the evidence indicated that the testator clearly knew how a right of survivorship would operate after he died, and armed with that knowledge, he proceeded to set up the joint accounts with the right of survivorship. So here, that money did not flow back to his estate, went to his children, and the charity would take under the will, but wouldn't get access to this money. Contrast that with the result in Colston and Dixon, a 2014 decision. Here, the testatrix made a will in 94 and also in 2000. Both wills divided her estate equally between her son and daughter. And if one of those children were to die before the testatrix, then the share of that deceased child would pass to that child's children. And after executing her second will, she created 3 joint investment accounts with her 2 children. The son predeceased her, so he died before. And so when she died, only one daughter was the survivor of those joint investment accounts and claimed all the money for herself. And the son's children, who were entitled to their father's interest under the will, brought an application for a declaration that their aunt, the daughter of the deceased, held the joint account assets in trust for the estate, and they were not hers. And the court, in this case, found the assets in the joint account were held in trust by the daughter for the beneficiaries of the estate under the will. And the evidence here indicated that the testatrix treated her children and grandchildren more or less equally, and it was as she reflected in her 2 wills. And the testatrix also had a great relationship with both of her children and her grandchildren, and the daughter had failed to rebut the presumption of resulting trust. So what is the takeaway for you listeners who likely have joint accounts or may very well have joint accounts as part of your assets, perhaps with children, perhaps with a spouse? How do you want the money in those accounts to pass? To the survivor, or do you want them to go to your estate? Do you want to make a gift or not of that money? And you need to think about that and discuss your intentions with your lawyer so that it can be clearly reflected in your will. Otherwise, if assets passing outside of the estate means there's less in your estate for your beneficiaries who may be different, this could result in litigation. Similar to, and I'm going to move on to my sixth topic, which is beneficiary designations, which is similar to joint accounts. In joint account scenario, we have two account holders. In beneficiary designation situations, it's where you are the account holder of an RRSP or perhaps a TFSA, a RIF, or some other investment account, and you can designate who is the beneficiary of that account when you die. And in Ontario, there's some conflicting case law on whether or not resulting trust applies to beneficiary designations. I'm going to discuss those two conflicting decisions. The first is Kalmuski, a 2020 decision from Ontario. So in this case, before dying, the testator had designated one of his sons as the beneficiary of his RIF. However, the will was silent on the RIF, said nothing about the RIF. And after the testator died, a dispute arose as to who actually owned the funds in the RIF. Was it the son who was the designated beneficiary or the estate? And here the court found that the RIF belonged to the estate and not the son. The court reasoned that the presumption of resulting trust applied to the RIF beneficiary designation, and the son had the onus of establishing that the testator intended for the son to have ownership of the RIF, and he failed to discharge it. And this was a very controversial decision when it came out, and it caused a lot of uncertainty amongst the state litigation bar, and also there was uncertainty in the banking industry because beneficiary designations are commonly done for investment accounts, done as a matter of course when you set up the account. And so I'll just skip to the next slide because I'm running out of time. But there was a decision a year later called Mac Estate and Mac, a 2021 decision, where the court came to an opposite conclusion and was critical of the Kalmuski decision. So in this case, in 2007, the deceased designated one of her sons, Kenny, as the sole beneficiary of her RIF. After the deceased passed away in 2015, the deceased's other three sons, who, along with Kenny, were equal beneficiaries under the deceased will, brought an action for a declaration that the funds in the RIF were the subject of a resulting trust. And the court found that the RIF belonged to Kenny and didn't pass to his estate. So the court departs from Kalmuski and reasoned that the presumption of resulting trust does not apply to a beneficiary designation for a RIF. And the onus is on the party challenging the RIF beneficiary designation to establish that the deceased intended for the RIF funds to go to the estate. And the reasons why is that the court found that the resulting trust was not an appropriate concept to bring into beneficiary designations. And because it was applied to the context of joint accounts, which are gifts while made alive. Beneficiary designations are not inter vivos gifts, which are gifts made when you're alive. They are testamentary gifts, which mean gifts that take place on death. The whole point of a beneficiary designation is to specifically state what is to happen to an asset on death. It's not the same as with a joint account. And also there's legislation under Section 51 of the Succession Law Reform Act, which states that an individual may designate a person to receive a benefit payable upon a plan on the participant's death, and that includes a RIF beneficiary designation. So got some inconsistent case law in Ontario on this issue, but again, something to discuss with your estate planning lawyer to make sure that whatever your wishes are, your intentions with respect to your beneficiary designations are clearly set out so that there's no uncertainty after you've died and there's no litigation or risk or a reduction to the risk of litigation in the event of any after your death. So that brings me to the end of my presentation, and I thank you so much for attending and listening. And I also want to thank our articling student, Christopher Cook, for his assistance in preparing the PowerPoint presentation, which you've just viewed. And I'm opening up the floor to questions now. Thank you very much.
Wonderful. Oh my goodness. Wow, Rebecca, thank you. You've shared a wealth of information. Thank you for taking the time to speak at today's webinar and for being a guest speaker. You've shared lots of practical tips from your courtroom experience and lots of case studies as well, which is phenomenal. Sometimes, you just never know what can happen. And my key takeaways are be careful with any holographic wills and handwritten notes, to also beware of any promises that are contrary to to what I write in my will. Certainly making sure that any jointly named executors get along and are trustworthy. Be careful of those sudden disinheritances and changes to will that are very different from previous versions. And of course, the joint accounts and the beneficiary designation piece for sure. So thank you. You've shared a wealth of knowledge, and I appreciate you being here, because it's so important that we need to protect ourselves and our loved ones with properly drafted wills to ensure that our wishes are met. So let's begin. We can now go into some questions. And so we'll invite our audience members to feel free to write your questions in the Q&A, and we'll certainly get to them, as many as possible. It's at the bottom of your where those are. All right, so our first question is, I understand to create your own will, you need two witnesses. Can the two witnesses be related to each other? For example, husband and wife, brother and sister?
So if it depends. Do you mean if they're witnesses, like someone is witnessing the other's will?
If they're, yes.
The witnesses cannot be beneficiaries under your will. So that's something to take in on board. And this is something that when you go to see a lawyer to prepare your will, that lawyer will know all of the protocols that need to be respected in ensuring that your will is validly witnessed. So spouses would not witness each other's will, presumably if they're beneficiaries of each other's estate. And that said, you can still have a relative witness a will, or a neighbor or a friend, as long as they're not beneficiaries. So they shouldn't be interested. The witnesses, in fact, they don't even need to have any relationship with you. They just need to be there and in the same room together. The two witnesses have to be there in the same room together and watch you sign the will. And then they will swear. One of the witnesses should swear an affidavit saying, I was in the room and watched that this person signed their will with the other person in the room.
Great. All right, thank you for that answer. Next question. Can you include your funeral wishes in your will? For example, cremation option.
Yes.
Perfect.
Yes,
Helpful.
I think, and you can also, I believe, include it separately. Again, that's something that you would discuss with your drafting lawyer, the one who prepares the will, in terms of making sure those instructions are carried out. They don't have to be in the will. It could be separate, and instructions to your executor to do that.
Okay, perfect. There's another question here. I already have a valid, up-to-date will. Will this be enough to carry out my final wishes?
It should. It should. A will could be drafted 30 years ago, before you've died. It doesn't have to be a recently drafted will, but it's always a good idea to every few years, or where there's a life change, such as marriage, divorce, death of a spouse, birth of children, children or grandchildren, if you want to benefit them, to revisit your will to make sure it still reflects your estate plan. And most drafting solicitors, when they give you the will say, I'm not going to send you a reminder to update your will, but you should come back to me or think about your updating your will in the event of life changes.
Good advice. Okay, perfect. Next question. Thank you for that one. This one here is, what if the person I name as my executor and contingent executor both die before me or become ill and can't do what's needed to distribute my estate? What happens then?
Someone else has to step in and do it and bring an application to be appointed. And then that will be on notice to whoever your beneficiaries are. So it's good also, if that's the case, if you have two executors who've been named in your will and you're concerned that they're perhaps getting older or unwell, or they've moved out of the country, that you should update that designation and choose someone else.
Okay, perfect. And then just, I think I know the answer to this, but what happens if you die without a will? How does your estate get divvied up?
So that's a common question, and it happens more often than not. And the law decides. So I mentioned during my presentation the Succession Law Reform Act. There's a section there that talks about intestate succession. So dying intestate means you died without a will, and the law determines the distribution of your estate and the order, the priority of who gets to inherit. And it depends on whether you're married and whether you have children, and there's priority. So for example, if you're a single person who has no spouse, no kids, and no other dependents, then it goes to your parents if they're still alive. If your parents aren't alive, it goes to your siblings, and so down the line of the bloodline, essentially. And so it gets distributed that way. And then if you're a spouse with children, if you have a spouse with children, then your spouse gets a preferential share, and then a third, and then the rest gets divided between how many children you have. So it doesn't, if you don't want your estate to go that way or benefit the people that the law say must get, if you die without a will, then you should do a will, because then you could change that distribution.
Perfect. Yeah. If you want a friend, for example, to inherit part of
Right.
the will, that will never happen if you don't have a will, obviously.
Exactly. Or there's no discretion. It's hard and fast. So yes.
Okay, good to know.
And also I should point out that if you die without a will, there's no executor. So it's a more complicated process to get appointed. Somebody has to step in and be your estate trustee. There's no automatic appointment. So that's another risk of dying intestate.
Yeah, that's good. Good to know. Okay, our next question from the audience is, what happens when someone contests your will? This person says, I've heard of a 3-year battle where disinherited adult children fought their mother's decision. What rights would they have to this? Or I guess to the inheritance.
Right. So again, that goes back to my topic of sudden disinheritances. I guess whether someone chooses to battle the estate or not, they may have different motivations and different financial resources to fund the litigation. Whether they're successful at the end of the day is another question. And oftentimes you don't know how strong your case is until you've gone down the road of litigation. So if you don't know, say there's a will and you're disinherited from the will, were you a beneficiary under the prior will? How much do you stand to gain from the will challenge? And what evidence are you going to find to support your will challenge as you move forward in the litigation? So in Ontario, you would challenge the will, and you have to have some evidence to show why the will would be invalid. So you can't just challenge a will because you don't like what it says. Even if you're a child, as I mentioned during my presentation, you have no entitlement or right to an inheritance, right? So it's not like I'm entitled to my fair share and I don't like that I didn't get my fair share and I'm going to challenge the will. You have to have some basis. So it has to be, is there an issue of testamentary incapacity? Was the will properly executed? Does it have, were there suspicious circumstances surrounding the making of the will? Was the deceased being unduly influenced by someone into making that will? And so their will was overrun by the wishes of someone else. And so that's why you were disinherited. So you have to have some kind of grounds and you have to have evidence in support of them. If you get over that threshold, then you can probably get information like medical records of the deceased to try and build a case to show that they were incapable, or go into the drafting lawyer's file and get that compelled for disclosure by court order and take a look at what that says. And did the lawyer do a good job in taking instructions and making sure the testator was capable and not subject to undue influence? So there's a lot of different factors at play. So the short answer is yes, you can challenge a will, whether you have grounds to. I guess it depends on the circumstances, but you don't have grounds simply because you don't like what the will says.
Yeah, for sure. That's an intricate process. I can see why it's very convoluted when things are not done correctly or contested, and what can happen down the road, for sure.
Definitely.
All right, we have time, I think, for just one more question, again from the audience. So if I designated an executor in my will and I no longer want this person to be my executor, how can I remove or switch them out without redoing the will? Can I do this myself?
You could do a codicil is usually sufficient. So it's an amendment to the will. You can do the holographic codicils can be valid, but as I mentioned, there's always risk when you do it yourself. So I would say the best course is to go see your lawyer and change the appointment of your executor.
Perfect. And Rebecca, any final thoughts that you'd like to share with our audience?
No, other than everyone should go and review their estate plans after this presentation and go see their lawyer if they feel they need to make any necessary changes.
Perfect.
That would be my advice. Or do a will if you don't have one, because I saw that there was 27% of our listeners had no will.
For sure. Good advice. We'll get on that. All right. Well, thank you so much to you, Rebecca, for answering our questions, and to our audience members for participating and engaging Rebecca in your questions, some great ones for sure. I do hope that the information and the tips and the strategies that were shared today will be helpful to each and every one of you. And if you'd like to explore any of these options further, I'd certainly encourage you to reach out to Rebecca at devriselitigation.com. Or consult your own wills and estate planning lawyer who can help you draft the will and get that first step going, or get that revised will going, and make everything proper. And of course, speak to your wealth and tax advisors on your own unique situation, because some of these may or may not be applicable to you. So of course, thank you once again, Rebecca and participants, for being here, and we appreciate you sharing all your wisdom and advice with us today.
My pleasure. Thank you.
Of course, to learn more about this event or any other legacy information, feel free to visit York University's website at myyorklegacy.ca. We appreciate you all being with us here today. Hope you enjoyed today's event, and have a great day.